Good evening, everybody. I hope you are all doing well, and I hope that it is not too cold where you are. I'm in Atlanta. It was actually really cold here for a couple of days last week, and it seems to have moderated a little bit. I'm hoping that we will not have any more of this frigid 32-degree weather, 28-degree weather. It was really, really cold. Not a fan of cold weather. Can't really exercise too much, and just not a big fan overall. As far as Social Security, not a whole lot of news to report at this point. As you know, there had been some talk about changing the rules to make age less of a factor. That was withdrawn, but now I'm hearing it's still kind of in the background. So I'll keep you informed as to whether or not that's something that may or may not happen. Right now, it looks like it's not going to happen, and hopefully it won't. Does not seem to be a priority, but I think we definitely want to keep an eye open for that. We still have, and I think I've talked about this before, but the grid rules are just an amazing tool if you're over 50, and even more so if you're over 55. I'd strongly recommend, if you're thinking about filing and you're over 55, I'm just looking at my cases that I'm getting favorable decisions on. A lot of them are over 55. Every single one of them, the grid rule is referenced. So I think judges are very, very aware of it, even if you don't have physical limitations, which, the grid rules technically only apply if you have physical limitations. But even if you don't, I think there's a bias in the Social Security system in favor of people who are over the age of 50, and even more so over the age of 55. So if you're over 55, I definitely would tell you this is something to really take a look at. Let's kind of go. We don't have a whole lot of comments at this point. Let's see. We've got a good evening, which is always nice to see. Good evening. Hello. How are you doing? We've got a hello from Maxi4 MVP. Hello. Dimple Bellamy, one of my regulars. Good evening from Ohio. Hope you're doing well. I did have a couple of questions on the, let me go to the YouTube channel because I did have a couple of, oh, here we go. We've got some, they've just kind of popped in here. I know this is time of year, people on vacation, going to holiday parties and so forth. So, we'll just see how it goes today as far as how long we go. It depends on the questions we get. Christina Harrington says, just had my hearing after I described my back pain and hemiplegic migraines. The judge interrupted to say she thought she had enough information. No questions asked. The vocational person's 52-year-old. That means you won. Normally when a judge says that he or she has heard enough, that means you've won. Because if the judge was to deny you, you would have grounds for appeal that the judge cut off your testimony. So I think here, anytime that's happened to me, means I won. So congratulations. I believe you did win. Always a good thing. It's really nice when the judge tells you. They don't normally tell you, and I think part of the reason for that is that at one point when we did live hearings, there was really no security in disability hearings, and so you would appear in a room, not a really big room. You would appear in a room with the judge, a vocational witness, and your attorney. And I think the judges were concerned that even though they had a back door they could theoretically get out of, in most cases, not always, but a lot of times they could, they were concerned that if they announced a decision and they had an unhappy person, that unhappy person might physically attack them. In fact, there were a few cases like that. So I think that there came a point, probably around the time I started about this about 30 years ago, where Social Security told the judges, just don't say what you're going to do. Wait and do it in writing, and that way there won't be any kind of issue as far as safety. So that's what they've done. I would say about 10 to 15% of the time, the judge will say to the claimant, the attorney, again, either I've had enough, I've seen what I need to see, I don't need any more, or I'm going to go ahead and find that you're disabled. I'm going to approve your case. I encourage you to continue to go to the doctor, and I wish you the best. They don't always do it, but they do sometimes. That's obviously a nice thing to do. PNW Patriot. Hello, appealing an onset. And at the VA file put in when I was 53, they said I could do a job, even though 6 disabilities are severe. And then let's see, let's see what we got here. Tried to work, I couldn't be 55 soon, worked as a sailor for 30 years. That's why they didn't give the onset date. This is a question that, in fact, I deal with this on a fairly regular basis, where I have a case that's approved at initial recon, and the onset dates changed. I had one I was working on today. The original onset date was in 2023. Beginning of 23, they changed it to December of 24 rather. And it ended up being 18 months of benefits that were being lost by changing the onset date, which, $2,000 a month, that's $36,000 a year, whatever. I mean, it's more than that. It's a lot of money. I think it was close to 50, I figured out. And so my client and we're discussing it, I wanted to look at the medical and just get a sense of what was going on. And what I tell my clients when that happens is, I say, look, first of all, you have the right to appeal the onset. You've got 60 days to do it, plus 5 days for mailing. So 65 days to make a decision. If you appeal the onset date when it's an administrative approval with the changed onset date, the risk is you go to a hearing, the entire case is back on the table. The judge is not bound by the administrative approval. So in theory, you could have a judge saying, you were approved at the initial recon, I'm going to find you not disabled. And what that means, obviously, is that if you've been collecting benefits for a year and a half, you're overpaid. You got to pay them back. And then you have to, obviously, you want to appeal the decision. So there's risk there. And generally speaking, if I'm looking at a $5,000, $7,500 difference, I don't know if the risk reward is there. If it's 20,000, 30,000, 50, 100,000, yeah, I think it's really something to look at. And what I do is I will do a quick medical review of the case to try to figure out where Social Security came up with that decision. Now, if in changing the onset date, if, for example, they changed it because the person turned 55 in August of 2024, you got to be careful because that's a grid rule case. And, the chances are a judge is going to probably do the same thing, which again means that there's not a lot of risk there, but you get a bad judge and you got a big problem. So it's kind of a case by case analysis. I look at, how much money is being lost, and I look at the underlying medical and how much risk tolerance my client has. I had a case this year, $100,000. My client, nope, don't want to appeal it, don't want to risk it. Okay. That's what he wanted to do. I think he was a fool to do it, but that's what he wanted to do. So anyway, you're saying that they found you disabled. Looks like it says an onset. So I don't know what onset day they found for you, but my guess is they're cutting you out of 2 or 3 years of past due benefits. And so, if it's $75,000 or $100,000, I think you got to really look at it. My feeling is that if they approved you administratively, that's a really good sign. If you're over 50, if it's, they approved you at 55 when your onset was 53, you still have a grid rule argument, probably not a ton of risk. The wild card is you get judged 15%. And there are a couple of them out there. And in fact, when I do one of these analyses, I look at the hearing office my client's assigned to. And if I see, if there's 6 judges and I see 2 of them have, really low approval rates, that's going to factor into it. So a lot of different factors. I do just kind of an overall analysis where I look at the money, I look at the dates, I look at the medical. Ultimately, my client decides, but I'm, going to offer my opinion. But that's the way you got to deal with it. Cheryl from Ohio. Hello, Cheryl. Hope you're doing well. Ginger Mittens Pirates. Stephen Cassandra from Dover. Thanks. Thank you, Stephen Cassandra. Good to see you. I think y'all have been here before. Good to see you. Maddie, from my staff, how are you doing? We are good to see you. Every time you have a different name on your YouTube channel. I don't know if you've got a bunch of them like me, but Madeline is a call screener and legal assistant at my office and does a really good job. And we're happy. I'm fortunate to have her. I'm glad to see her here today. Jeff Brown. Hello, Jeff. How are you doing? All right. This is going back to a person with the onset date issue. And by the way, let me also address this. You could go to a hearing and the judge could approve you, but change the onset. That's called a partially favorable decision. Same issue. You can appeal that to the appeals council, but if you do, and it goes back to a judge, the entire case is now back at issue. And that could be, that could result in a denial. So you got to be really careful about that. And that's where an attorney can, look at it and kind of give you an idea of hey, this is something you might want to really think about doing or not doing. So that's just, again, case-by-case analysis, and hopefully an attorney who's done this for a while will be able to give you a good insight. Now let's get to PNW Patriot's question. What should you ask of the VE vocational witness to show that you're not able to do light work? Well, first of all, that's not the way to really look at this question. VEs answer questions from the judge based on their knowledge of what works or doesn't work in the work world, what type of limitations apply. So if a judge asks a question with very minimal restrictions, very mild limitations in terms of not being able to do very much, they can lift 30 pounds, for example, or they can stand 7 hours in a day, and they can climb ladders. Well, it doesn't matter what the medical says. The vocational witness is answering the question from the judge. If the judge gives minimal limitations, then guess what? The vocational witness is going to say there are jobs that can be done. So that's one thing. The second thing is, there are times when vocational witnesses will identify jobs, and you look at them and you say, does this job really exist this way? Or could the person really do a job given these limitations? I was looking at on the listserv, and there was a question that came up on the listserv about a person who had, I think, a 9th or 10th grade education, minimal reading and writing skills, and there was a couple of jobs that were given by the vocational witness. And the lawyer's question was, isn't it reasonable to say that a person with a 9th grade education, minimal reading and writing skills, that almost every job out there would be a problem, that every job is going to have some written instructions or have the need to communicate or read something minimally? And, you can certainly make that argument, and there are probably statistics out there. So yeah, there are ways to attack a vocational witness. Hard to do if you're not a lawyer, because you're not going to really know what the resources they use. They use different vocational resources, the Dictionary of Occupational Titles, which is an outdated one they still use. They use Job Browser Pro, which is a computer program that kind of combines a number of different things. There's a bunch of different resources. I will tell you, the bottom line is that nobody really knows how many jobs exist in the economy for any particular occupation. They'll give, cashier 2 is a typical one they come up with, or laundry marker. Nobody's counted. We don't know how many laundry markers are there. They use generalized statistics. A lot of times they are deduced from bigger pictures. So, there may be a big category of which there are 15 jobs, one of which is laundry marker. And what the vocational witnesses will sometimes do is they'll divide the total by 15 and say, that's how many laundry markers are. Well, that's inaccurate, because, of the 15 job categories, what if 3% are laundry markers and 97% are something else? So we really don't know. But Social Security persists in using this kind of fiction. So yes, you can challenge a vocational witness on methodology. And there is, in fact, a ruling that came out that Social Security sort of gave a safe harbor to vocational witnesses that say, if you answer these questions in the affirmative, we're going to assume that you are being reasonable in terms of your estimations. It's a bunch of hooey, if you ask me. Now, there are some attorneys who go after vocational witnesses with a vengeance, and they'll go after them really hard to prove that they don't know what they're talking about. And in some cases, you might be able to get an appeal on something like that. Typically, judges will ask a vocational witness to identify 3 representative jobs. So it's not saying these are the only 3 jobs. Usually but here are 3 examples of jobs. There are many, many more. And so even if you can say this one job doesn't really exist anymore, there's for example, and I don't want to get off on a tangent, but there's a job out there called surveillance system monitor that used to be used a lot, and by vocational witnesses is one of the easiest jobs that exist in the economy. Well, Social Security, came out with an emergency message that said, we're no longer going to consider surveillance system monitor as a viable job, because there aren't very few of them at this point. And there's other job, microfiche operator. There's just a bunch of these jobs that are, in the DOT from 1990 that don't exist anymore. So even if you can prove that the vocational witness came out with one of these ridiculous jobs, what they're saying is this is a representative sample. Here are two more there. My feeling has always been if you're having to attack the VE based on job numbers or based on the jobs they come up with, you're already losing because the judge is sort of given the question. Judges know the answer to the questions they're asking. So they've given the VE a question that they know the answer is going to be that there are jobs. So yeah, you could go after the details, but you're making a tactical decision, not a strategic decision. Far better, in my opinion, to make sure that you have strong medical so you can go back to the VE with your own hypothetical, assuming that the court accepts, Dr. So-and-so's assessment that the claimant can only sit for 15 minutes at a time, no more than 3 hours in a day, and needs to take 4 unscheduled breaks. What does that mean? Well, that's going to mean no jobs. That to me is a stronger argument. And I understand why some lawyers go after the VEs. They realize that this is just, they're just made up numbers. But I just have not seen judges be very receptive to it. If they get a remand, they'll go back, and maybe they go back to the judge, and the judge is like, well, if the appeals counsel or district court thought enough about this to remand it, I'm just going to go ahead and approve it. It's just a long way around. And my feeling is choose winning cases and make sure the medical is strong. That to me is a better argument than going after the VE. But if you're asking, I think at a minimum, what to ask the VE would be to have your own hypothetical that reflects your medical records and ask the VE to comment on that. A person limited to light work, no climbing ladders, ropes, and scaffolds, limited to simple entry-level 1 or 2 step unskilled jobs. This person needs to avoid overhead reaching or use of foot controls. This person would likely be off task is sort of a catch-all for 15% of the day, or this person would likely miss 2 or more days of work per month because of symptoms. That's going to get you the answer you want. But you've got to get the judge to incorporate that answer into the decision. That's the hard part. But bottom line is, for me, going after vocational witnesses on picayune details, most of the time I think you're rearranging deck chairs in the Titanic. My opinion. There are other lawyers who would vehemently disagree. They think that vocational witnesses are always subject to attack because they're always wrong. They always are giving information that is based on conjecture and deduction, and it's not logical. And if the courts, occasionally you'll see a decision from an appeals court or from the district court of appeals that recognizes a really absurd situation. Yes, they'll remand it, but a lot of times it just doesn't go very far, and that's the problem. I mean, to me, I'm trying to get my clients approved. I'm not trying to make law. I don't want to be in the case books. I just want to get my client approved, and so I'm focusing on choosing good cases, and I'm focusing on making sure I've got good medical. The people that go after the VEs and go that route, more power to them. Happy to refer those cases to those people. I just don't know that that's, as a matter of business strategy, it's not I don't think a great call. And I think at the end of the day, you're really fighting City Hall, and that's just really a hard way to go, my opinion. But I think that, to answer Patriot's question, I think you want to make sure that the hypothetical you ask or multiple hypotheticals contain specific and work preclusive limitations. You always want to have one that talks about being off task 15% of the day, missing 1 or more days of work per month. That will always get you the answer you want. But at the end of the day, try to get the hypothetical question to give you the answer that you want. And, on appeal, theoretically, you could challenge the judge's question because it's inconsistent with something else in the record. But again, very, very hard road if that's what you're left with, is going after the VE if the medical is weak or the medical does not say what you want it to say. Okay. Something Kiana Mini, 1316. Good evening. Hope all is well. I submitted my short form CDR. maybe 2 or 3 weeks ago for CRPS. CRPS, if you don't know, is chronic regional pain syndrome, used to be called RSD. It is a pain syndrome where a person has terrible pain. It could be in the hands or the feet or any part of the body, really, but a lot of times it's in the hands, that there's really no organic cause for. An example, I had a friend of mine who was in a car accident and jammed her hands really tight on the wheel when the accident happened. And, there was not a lot of structural damage. There was no broken bones or torn ligaments, but she developed this incredible pain in her hands and couldn't close her hands. And she was a dentist, so she was actually making very good money. Couldn't close her hands, couldn't do her work. And for, I think, 7, 8, 9 years, her hands were swollen and red and uncomfortable. And gradually it went away. She had CRPS. And in her case, she was able to get long-term disability for it. Probably could have gotten Social Security as well, although, again, there are other issues that could have arisen for that. But bottom line is that CRPS is one of these things where it's somewhat subjective in nature, meaning that there is no real test for it other than the doctor's evaluation and clinical signs. You might have to be evaluated by a psychiatrist or a psychologist to make sure there's not a mental health component to it. They're difficult cases. Any kind of case, fibromyalgia, chronic fatigue, CRPS, a lot of these conditions don't really show up on objective tests, but they're very real. They're very real. In fact, I just read a very interesting opinion. I hadn't finished it yet, from the Fourth Circuit about fibromyalgia, where they basically talked about it is not a condition that there's objective signs for, but it's very, very real. And judges have to consider the subjective nature of it. So I think what the message I'm getting is that if you have a lot of ongoing treatment records, and your doctor finds you credible and you're otherwise credible, a person, again, an example I gave, who's making 6 figures as a dentist, is not going to stop working to sit at home and hopefully collect, a third of her income from long-term disability and whatever they're going to get from Social Security. So that factors in as well. So hopefully, in a CRPS case, there's ongoing medical that supports you. Hopefully, there are some objective signs, whether it's swelling or redness, that are consistent with that condition, and there's an underlying trauma that would result in it, and that hopefully Social Security will realize this is one of these conditions where the subjective evidence should be given a lot of weight. As far as how long it takes, it could be 3, 4, 5 months. It just really depends on the workload. And they'll send you a notice saying, we've decided that your disability remains ongoing, no problem. Or they'll say, we've decided to move to terminate you, in which case you can file an appeal, which is a request for reconsideration. And they give you a whopping 10 days to decide whether you want to have your benefits continue while you appeal. And the problem there is that if you elect to have benefits continue while you appeal, there'll be no accruing benefits, meaning you cannot get a lawyer on contingency. There's no money to be paid from. Or if you say, well, I don't want my benefits to continue, that means for the next year and a half, you have no money coming in. It's a really difficult choice. But I think that, how likely will you be approved? It just depends on what the medical evidence says. There seems to be a little bit of a trend more in favor of Social Security accepting some of these subjective complaints. So maybe that'll work in your favor as well. But I can't give you as an answer percentage because I don't have not looked at the evidence. Mark, one of my clients, and he notes they just changed the diagnostic criteria for multiple sclerosis. Where was that, Mark? Where did they change that? When you said they, you talking about the medical people or Social Security? Tell me what you're talking about, because I need to look that up. I'm guessing you mean it's the medical criteria in terms of what constitutes different levels of multiple sclerosis. Interesting disease because there's different subtypes of it, some of which progress very quickly, some of which are a little more slow. But I'd be interested to know more about what you have to say. So either email me offline or comment below. That would be helpful. Lake City Bricks. Good evening. You had a hearing today. Sounds like a bench decision. Great. Decision will be in the mail in a couple of weeks. Great. That's awesome. Yeah, I've had a number actually in the last few weeks. I had 2 cases where I literally tried the case. The approval was issued within 2 weeks and the money hit within a week. I mean, this is all within 3 weeks. Hearing, approval, money. Really, really wild. Actually, I had one very sad case. Client had a very strong case, but he passed away. And medical there was really no medical. I mean, I happen to know he passed away because of his underlying medical condition, but I don't know that Social Security necessarily knew that. But I notified the judge, and the judge issued a decision, a written on the record decision in that case. I put in there, just my thought as to what had happened. But again, there's no evidence to that effect. But I mean, it was, I think, reasonable to expect, given the nature of his condition, that was going to happen. But they approved that again in writing. So I kind of get the sense there may be a little bit more of an effort to clear out the backlog by, giving these cases that clearly should be approved, move them a little more quickly through the process. Hello, Bonsai Boyle. Hello. Watch your videos. Yeah, I've been doing this for, I guess, closing on 10 years now. Hard to, maybe even longer. I did my first video. My first video was terrible. I mean, I didn't know what I was doing. I had this big old microphone, and I had a camera with a videotape. It was not HD or anything like that. And my lights, I bought some lights, not knowing any better. And this was a long time ago, that had fans in them. And of course, the problem is the fans make noise. So you're hearing, it sounds like I'm in a wind tunnel talking in this microphone with this old camera. It was pretty bad. But, got to start someplace. And in fact, I would tell anybody who's, thinking about doing a YouTube channel, or any sort of marketing, whatever, whether it's video or, blogging or websites, you got to do it. I mean, you just got to, the first is going to be terrible, and then you just kind of go from there. And, over time you start getting good at it. And that's sort of what happened with me. But yeah, the first ones are pretty embarrassing, but you listen to a lot of these channels about YouTube and all that, and they all talk about it. My first ones were bad, but as you start to get your sea legs, it starts to get better. So anybody out there thinking about doing it, I would say just do it. And by just completely off topic, but I'll just mention this. There's a lot of, because I follow a lot of this marketing talk on YouTube, very podcasts and blogs and videos and things like that. There's a lot of push out there, what they call the faceless YouTube channel, where they have people you can get stock footage. There's all these sites. Storyblocks is one of them, where you can now go to the AI tools and you can have it generate a video, which is really kind of cool. But you could theoretically do a whole video, and you can have a service that will narrate the video, where you can do a video without your being present, without your talking, all made by computer graphics and artificial intelligence. And it's tempting to want to do that. If you're thinking about doing a YouTube channel or podcast, don't do that, because I think the search engines are aware that this is artificial intelligence content, and they won't give it any weight. So, there's no such thing as a free lunch, and that isn't one. I know I have people on here who've emailed me, about, asking about videos and so forth. And so again, if you're in that boat, just do it the old-fashioned way. Just do the videos. And not to say you can't use AI for brainstorming, but you can't, shortcut everything. You got to actually get out there and do it. Okay. I appreciate Mr. Chicken Lips. I'm not even going to ask where that came from, but okay. I appreciate the counsel. Good. I'm glad that's the goal here. I mean, I think this is, that's actually the goal of this channel, this live stream, is to give people a little insight into the black box that is Social Security. There's not a lot of great information out there. There's a lot of discussion websites, Social Security and others, giving rules, setting out the legal parts. But I'm trying to give you what works. I've done this for a long time, so I can tell you what the rule says, but I can also tell you this is what you're going to need to win. And that's really what the goal is. And so I'm glad that you found this useful, because that's really what I'm trying to do. All right. Somebody else follows me regularly. Eunice, who's been here before. If I apply for a pension, to my knowledge, no. I know that there are some federal programs, FERS would be a problem, and I know that workers' comp would be a problem. But to my knowledge, a union pension for an SSDI case would not be an issue. I'm not giving you legal advice on that because I haven't researched it, but to my knowledge, I've never seen a pension create a problem. So, you might want to ask the union folks, are they aware of any implications or any problems with Social Security disability if somebody takes a union pension? My gut would tell me no, but again, I would do your research on that, but I'm not aware of it that it would. Christina. Christina is here almost every single week, and she is always very supportive of the channel, which I greatly appreciate. And she's like, hello, friends from California. Hello, very much. Okay, so Bonsai Boyle is a person who I think watched me for a long time. You received, it looks like a CDR form, probably a 454 or 455. One's the short form, one's the long form. I think you just got to fill it out. I mean, realize, when you fill it out, you keep in mind, number one, that you want to focus on vocational limitations. Don't say not very much or not very far. You want to be very, very specific as to the things you can and cannot do. So that is one point. I think the second thing I would tell you is when you fill out the form, if you've gone to the doctor, make sure that you put your medical information, updated medical information in there so they can get it if they need to. And otherwise, just let the chips fall as they may. I mean, if you have gone to the doctor, if your condition has not really improved, that's what you put on there. If you tried to work and it was not successful, put that on there. So, if you're still truly disabled and you still are having medical problems the same or worse than you were when you were approved, you should be fine. But yeah, it is a little bit nerve-wracking to receive one of these forms because you're like, are they looking for a reason to cut me off? And they are looking for a reason to cut you off. But certainly the older you are, the more difficult it's going to be. But you just got to hold your ground and make sure to get everything in on time, fill it out completely. But again, I implore you, focus on the functional, specific activity limitations. Eliminate not very far, not too long, not very much, a little bit of this. Get rid of that. That does not apply in this Social Security context. 10 minutes, 30 feet, 4 hours, whatever the case may be, 3 pounds. Be very, very specific and think about it, not on your best day, not on your worst day, but if you have if your day ranges from 1 to 10, 1 being miserable, 10 being you feel like, you could conquer the world, think about it on a day 4. So even though every day is a little different, just pick in your mind, a day that is 4, a little bit below average, not the worst, but a little bit below average, unless, every day is really a 2 or a 3, but assuming you have kind of ups and downs, and realize that you're not working. So you don't know how long you could sit or stand because you're not in a job. So you have to guesstimate, but realize for the most part, if you're, lifting is limited to 10 pounds or less, that's pretty restrictive. If you can stand for less than 6 hours, that takes you out of light work. If you have bad days where you need to be on the couch or in a recliner for 20 to 30 minutes twice a day to get the pressure off, that is a work preclusive level impairment. If you have, for example, migraine headaches 4 to 5 days a month where you're in bed in a dark room with a cold compress on your head for 3 to 4 hours, or until you fall asleep, that's work preclusive. So you just, I think one of the problems that folks run into, it's not their fault, but they don't have the perspective. I mean, I can't tell you how many times I've talked to clients, and this is particular men. I've had a number of men clients. One gentleman who was ex-military and, did training runs, was, just a really fit guy and, probably could lift 80, 100 pounds, could run, 15 miles. And so now, having some problems. And so I said, well, how much do you think you can lift? Oh, about 30 pounds. I'm like, 30 pounds? That's, how much 30 pounds is? That's a lot. 30 pounds is an awful lot to be able to lift. And I said, if I said to you, could you hold 2 gallons of milk in both one in the left and one in the right hand? Those are 8 pounds each. That's 16 pounds. Now double it. Can you hold 2 gallons of milk in each hand, 4 gallons of milk total? I couldn't do that. Well, there's your 30 pounds. So I think, you almost have to, step back and think about, what does a 10-pound bag of sugar feel like? Or a 10-pound bag of potatoes, 5-pound bag of sugar, and think about that, doing that all day long. Could you really do it? And again, this is where not to sound self-serving, having an attorney can be helpful, because when somebody tells me, well, I could do 50 pounds or I could do 30 pounds, I'm not going to say, no, you couldn't. I'm just going to say, think about that. Let's think about what weighs 30 pounds. It's a lot of weight. I mean, if you have a grandbaby who's, 2 years old, I happen to have one who's 2 years old, so I know, she's 30 pounds. Well, it's picking up a 30-pound wiggling toddler is not for the faint of heart. And, when they talk about 30 pounds, it's not always going to be, in a small package where you can hold it against your chest. It could be something that's moving around. It could be a large, wide box. So again, think about picking up a 2-year-old. Could you do that? Picking up a 30-pound dog. I mean, how, you get a medium-sized, lab or golden retriever, there may be 30, 45 pounds. Not so easy to pick up. So my point here is, when you think about your capacity on this sort of below average day, really think about what you could do. Maybe get some perspective from somebody who, can look at it and say, can you really think you can do that? Again, a disability attorney is a good person to have some perspective with it. But even if it's a friend, just say, do you think I could lift 30 pounds? Maybe go try it. Could you really lift 30 pounds? And think about, the Social Security world occasionally is 3 hours a day, and frequently is like 5 or 6 hours a day. So occasionally lifting 30 pounds means 3 hours a day you're lifting a 2-year-old toddler who's wiggling around for 3 hours a day, on and off. Can you do it? That's a lot to ask, in my opinion. So I think you just don't want to overstate your capacities when you're doing this, when you're filling out the forms. And so that's my pitch, is to fill out the forms, really think about what you're saying and make sure that it's accurate. Christina says, don't forget to share and like. Appreciate that very much. So in fact, I'm going to put up here, I do have the leave me review there. Okay. I'm going to put this one here. It says for a case evaluation. So I get yelled at if I don't do that. So I want to make sure I do that. Okay. Lake City Bricks had a hearing. There were no hypotheticals asking about absences and breaks. The judge said 1 to 2 absences, no more than 10% off task. Case is approved. This is a twice remanded case. Medical expert was not there. Okay. And that's, not uncommon. If a judge ends up with that, you're going to win. Now, I will tell you that judges will often end up with that level of impairment as one of their questions, but they end up choosing the question where there were jobs that you could do. So it doesn't mean you win, but you always want to make sure that that's in there. So again, that is, very, very common that there's, and that's the other thing. If a judge asks one hypothetical question and it has these limitations, 10% off task and 1 or 2 absences, and that's the only question they ask, you've won, because a judge isn't going to be able to deny a case based on, a unasked hypothetical, if that's grammatically correct. It's got to be asked. If they don't ask it, they can't then put it in the decision. You'd have grounds for appeal. That's a good, I think that's overall a pretty good sign. Bugs Moran. Okay. Yes. Thank you very much. I appreciate that. We work hard at it. Got a good staff, and we are, I know it gets people very frustrated how long it takes. And I wish I could do something about that. But, what I'm trying to do when it comes time for a hearing is make sure that the medical record is complete, nothing is left open, and that I know the file backwards and forwards. And I'm usually pretty good about going through, and I make a little worksheet where I abstract everything down to 2 or 3 pages. So I got it right in front of me, and I've read every page of the record. It's time consuming, but that's the way I like to prepare, and those seem to work. Okay, we've got another LMA, one at Recon. Great. No hearing. That's good. Very, very good. Well, leave me a review. I'll put this up there again. If you got benefit out of that and the videos, believe me, I mean, I'm thrilled. That is exactly what you want to see happen. I'm happy for anybody who can do it on their own. But if you do, and you're so inclined, please leave me a review. That would be most grateful. I'd be most grateful that does help me a lot to build my practice. And I got some interesting things coming next year. We'll see if they all come true. But I've got some really cool stuff just to try to come up with different ways to, share what I know. So we'll continue to do these live streams, but got some other stuff coming on board too. The judge challenged my closed period, found disabled at 10:22. Okay, I think this is from before about the change in onset date. Okay. Thank you, Stephen Cassandra. I really appreciate that. Thank you for the kind words. It is much appreciated. And you know what? I couldn't do this without my audience. And I'm fortunate I get, a bunch of regulars, and then sometimes we'll get people popping in. I've got some, I've talked to a couple lawyers that are going to come on as guests next year. So that's always kind of fun to have a conversation. I know Stephanie Joy and I've done it a few times. Adriana, who's an appellate lawyer, we've done it a couple of times. I'm going to get Spencer Bishens back, who is a former Social Security employee. I've got a couple other people lined up, so it'll be good. It'll be good. Thank you, Bama DRB. And if you are a Bama fan, sorry what Georgia did to Bama a couple of weeks ago. They just took them apart. But hey, it's the way they go. Bama's had Georgia's number for a long time, but now that Saban is gone, maybe the tide is turning a little bit. But anyway, happy to have all my viewers from Alabama and other states, but I know there's a football rivalry with Georgia and Alabama. Actually, my Green Wave, I went to Tulane for undergraduate law school, and every so often Tulane has a good year. They're not a football school, obviously a small school. And in fact, their coach, this guy, Summerall, is going to Florida. He got picked off and was going to Florida. And that's what happens at Tulane. They'll have a good year, and the coach, gets the accolades, and he'll get picked up by a much bigger school. And obviously going to an SEC school from, Conference USA, whatever Tulane's at, is not that big of a deal. But Tulane, because they won their conference, they're in the playoffs. So they're playing Ole Miss this weekend. And Ole Miss, I think Lane Kiffin, their coach, just left. So they got an assistant coach who's going to step in. Tulane, by all rights, should have no chance against Ole Miss, but you never know, so that would be kind of cool. Now, if they win, they would end up facing Georgia at the next game, and that ain't going to happen. But, it's kind of cool when when your alma mater actually makes a little bit of a run, especially a school like Tulane. So they have this interesting quarterback who's a transfer from BYU, and he's really got him, in a good place. So yeah, it's kind of cool. I'm not a huge Tulane football fan, because it's just they're not a team you can cheer for that much. But it is kind of cool when they do put it together. They do. What does your appeal was selected for quality federal? What does Boss Lady says? What does your quote appeal selected for federal quality review mean? What that means is that you were given an approval, and then Social Security, somebody, at a different level in the administration, flagged your case for review by something called a quality review office. It can be random. They don't tell us exactly what causes that to happen. I would say my experience, 85-90% of the time, quality review says, yeah, the judge made the correct decision, or the adjudicator, and they go on and approve it. But I had one, I got a hearing coming up soon, where they at the initial level, or I think it was initial, they approved it. Quality review said, no, you made a mistake, and they denied it. And then we're going to a hearing on it. And he was not happy. He didn't know this. My client, he was not happy to know that he'd been approved, and then quality review reversed it. And now he's got to go through the hearing. So, but that's what that means. So I would say, it's somewhat of a random thing to make sure that the adjudicators are doing their job. But there may be some algorithm in there that says, if they approved a person with a master's degree, if they approved a person with this condition or at this age, that it may trigger more of those. But I don't really know what the criteria are. It was 62 degrees in Eastern North Carolina. It was actually fairly warm today. Today wasn't bad. It was like in the high 50s, low 60s. And I'm hoping that that will continue a little bit. I know it's, I don't mind an occasional cold snap, but I'm hoping that will be. And I'm actually going to be we always take our family vacation in Hilton Head toward the end of the year. And so it's a little too early to know what the temperature will be there. But sometimes you go there and it's really cold. You walk on the beach in a sweatshirt or whatever, kind of windy, and try to play tennis and it's windy. Sometimes you go and it's 75 degrees. So we'll have to see. But hopefully it'll be nice weather and doesn't rain. That's the main thing. Okay. Good question. I get some really smart people, some very good question. All right, so the question one is, are findings on a DDE, which is at the adjudication level, considered a prior administrative medical finding, and can these be used as a reference in a recon appeal? Yeah, I mean, I think that, let's read the second part of this. Because the DD indicated several of my cases would be severe, but these were never developed. I was denied. Whereas the weight of citing these findings in a recon appeal? Well, first of all, let's define our terms. Social Security uses the word severe. That is a term of art, and severe is part of the 5-step sequential evaluation process. When Social Security evaluates a case, they use this 5-step process. And I'll go through the steps. Number one is, are you working or engaged in substantial gainful activity? If you are, can't go any further because you're not disabled by definition. Number two, do you have a severe impairment? And severe impairment basically means, is there anything out of that medical problem, anything arising from that medical problem that would create some work limitations? Doesn't mean to be disabling per se, that particular one, but is it something there? Is it a diagnosis where there's treatment? If they find there's no diagnosis and no treatment, they can deny it step 2, that there's no severe impairments. And so at the state agency level, when you look at the explanations of decision, they will say, this is, we found the following severe impairments. And it may be musculoskeletal, it may be mental health or PTSD, or maybe cardiac. It's not binding on a judge, but yeah, if you're following an appeal and I do a brief, and I'm doing a pre-hearing brief, I will make note, this DAS or DDE of adjudication found this impairment is severe. And I may say, but they also found that respiratory impairments were not severe. We think it is severe because of X, Y, and Z. Not binding on a judge, not binding, I don't think, on recon, but I think you can throw it in there, and certainly if it's not severe, if it's considered severe and they didn't send you for consultative evaluation or do anything to develop it, I think that would be grounds for appeal at recon. May not get you over the finish line, but it might cause them to send you out for a consultative evaluation. But yeah, I think that anything you have in your quiver, any arrow you have in your quiver, it was found as severe at the initial level. I'm at recon now. I have 100% VA rating. I have an MRI that shows a severe herniated disc. Anything you can put in there, you want to put in there. Don't hold back. There's no reason to. And the DAS, the adjudicators may not approve you because you're educated or because you're below 50 or because you have a skilled work background. That could be nothing to do with your medical impairment. They just may not be able want to talk, may not want to discuss transferability of skills. May not want to discuss a person working part-time. There are other factors that come into play beyond your medical that the adjudicator may not want to address. So that's what I would tell you is, yeah, I'd put it in there. There's no reason not to. And you can always add extra pages if you need to the appeal form. But yeah, put it all in there. Put it all in there. Lily, I'm on SSDI at 61. Does a ticket to work program protect from medical CDR? Do they assign one? I don't know anything about the ticket to work. I don't want to answer that question. I do not know. I'd put this in like ChatGPT or something and ask it. Maybe try 3 or 4 of the AI engines and just see if you get the same answer. We don't deal with the ticket to work. I don't know enough about it. I know that there's been a lot of controversy that it really doesn't work very well, but I'm not the right person. Who you might reach out to is either what is the guy's name? Ed. I'm drawing a blank. He's got a very good YouTube channel. Let me see if I can find him real quick. Ed Weir, Weir, mygovernmentexpert.com or mygovexpert.com. His email is ed@mygovexpert.com, or look up Ed Weir, Weir, as a, his YouTube channel. And Ed used to work for Social Security. He and I have talked a couple of times, and he would probably be able to give you a much better answer about Ticket to Work, because he dealt with this sort of stuff. So that would be who I would go to and ask, because he would have a better answer than me. Cynthia says, hello, Cynthia. How are you doing? Mail sorter. Mail sorter is one of those jobs where, it may be obsolete. I'm not sure how many mail sorter jobs there really are out there, but that's a common kind of unskilled job that may really not be that many of them. It may not be unskilled. So you had someone say microfilm, Lake City Beach microfilm. Yeah, that's bogus. Or I would bet you that half the people looking at this live stream have never heard of microfilm or microfiche. And what it is, in case your curiosity knows no bounds, is back before, obviously before the internet, before scanning was real common, things like that. What would happen is to store documents that you didn't have the original, they would take a picture of them using a special camera, and then they would reduce it down to really, really tiny size. The size of your thumbnail could have 10 pages on it, and then you put that, and that would be like on a film, and you'd put it into a machine that read it, microfilm or microfiche reader, and it would blow it up, and so you'd see on a little screen the text of it. And it was just a technology that was just a way to reduce things down and save space. Of course, now it's ones and zeros. It's on the internet or on a hard drive someplace. But back in the day, you had microfilm film operators or microfilm technicians. Well, there may be some legacy microfilm someplace that hasn't been digitized yet, but the number of people that could be employed dealing with microfilm is vanishingly small. So that is a job in the DOT from 1991 or 89 or something, doesn't exist anymore. And that may be one where they deemed it obsolete. But that's an example. So Jim, I'm not sure if Jim, you were saying you are a mail sorter. Let's just look that up. I'm just curious now. You've got me thinking it. Let's see what mail sorter says. Mail sorter. I'm looking at the Dictionary of Occupational Titles. I'm going to pull it up so you can see what this looks like here. Let me share my screen. I think that's not it. Yeah, that's it. Okay, so this is, let me see if you can see this, make that bigger. Okay, so this is the Dictionary of Occupational Titles. The job number is 209.687-022. This is a sorter, is the title of the job. A sedentary job, that's the SVP, sedentary. The SVP, which is specific vocational preparation, is 3, which means it's semi-skilled, but very low end. SVP 1 and 2 are unskilled jobs. And if you see over here, reasoning level 2, that's pretty basic. Mathematics level 1, there's no math there. Language level 2. So this is about as close to an unskilled job as you can get. And vocational witnesses will use this job as an example of a really simple sedentary type of job. Is it really that simple? Could you make an argument, going back to the person asked about challenging the VE, could you make the argument that a person who's a sorter needs to be able to have some computer knowledge, have to operate a scanner, know how to put items in a directory, that it's not really unskilled? Could you cross-examine a VE and say, well, isn't it true that most sorter jobs also involve saving files onto a computer network, or operating an email address and downloading from the email, and renaming a file? And wouldn't that be beyond reasoning 2? Wouldn't that make this more of an SVP 4 or 5 job? And you may have some vocational witnesses that say, yeah, That's exactly right. This isn't really an unskilled job or a semi-skilled job, low end. But, is that going to be enough to convince a judge to approve your case? Maybe, but it's still going to be a long way around. But that's an example of how you might go after a VE if they came up with a job like this. Okay, let us get back to the questions here. All right, so Lake City says the ticket to work does protect you from a CDR. And there are a couple of different agencies. And again, I'll take your word for it. Again, I would do your own research on that. There's probably not a lot of stuff out there on the internet. Again, this might be a task for ChatGPT or something. So see what it says. Okay, Christina says, do not forget to leave a 5-star review. Well, that would be great. Thank you very much. Let me just put this in here. So I talk about this sometimes and people don't know what I'm talking about. All right, so I actually have a website besides the SSD answer. I have a website that is called jonathanginsberg.com. And on here, there is a tab that says Review Jonathan. And I got my next picture there, which is really old. I got to get another picture because I don't look quite that young and vibrant as I did when I took that picture. And if you're actually one of my clients, here are places you could review me. And then I've also got on here video appreciation testimonials that people who have seen my videos and gotten benefit out of them and won their cases. This is also a way to give me a testimonial. So if you are inclined, you find this useful, please go to jonathanginsberg.com or follow that bit.ly link. And I'll put that up again. If you were inclined to do it, and just give me a nice review, and that would be helpful. That this came in handy for you, and all those things make a real difference in the way my websites get ranked by the search engine. So anything I can do that will help that would be cool. Okay. Hakasad for SSI, is there any such thing as reversible error and initial denial in our cases actually approved at recon? They are approved at recon. Statistically, it's like 15, 16%. I've had a number of approved at recon. A lot of times it's because at the initial level, the medical was not received. And so they went on and made a decision without that. It could be sometimes I'll put in the recon appeal to look at the grid rules where they didn't look at it before. It could be that that the medical evidence was improperly evaluated. They say it said something it didn't say, and the recon adjudicator got it right. So there's any number of reasons. You got to go through the process. I mean, you can't avoid it. You have to go through it. But yeah, cases are approved at recon, and it happens not infrequently. I'm not going to tell you it happens all the time, but it does happen. And I think that they're trying to get people that are should be approved, get them approved and get them off somebody's desk. Hey, Christy, can work credits fall off your record, just like date last insured after it expires? Well, work credits, and I don't know exactly how work credits work when it comes to retirement Social Security. I know they use like the top certain number of years of earnings. But for date last insured, yeah, I mean, they look at the last 10 years. So if, let's say you worked full-time and made $75,000 a year from 1980 to 1990, then you didn't work for 5 years, and you worked from 1995 to 2000. Then you worked from 2005 to 2010, and you're in 2025 and you're filing for disability, and you got a lot of work credits, but nothing in the last 10 years. Your date last insured is going to be back, way back a long, long time ago. And so those credits don't benefit you. When somebody reaches out to me, generally speaking, I'm going to be looking at their credits or their work. And when's the last time you worked? And they say, I worked full time, 2023. Okay, a couple of years ago. They're going to be fine. If it's within 5 years, that's going to be fine as long as they work more or less full time. But if they say, the last time I worked, and I'm doing this in 2025, end of 25, last time I worked was 2015, they're not going to be insured most likely. So, those are cases that are going to be SSI only. Or sometimes people say, well, can I prove that I was disabled back, my date last insured for Title II disability was 2017. Can I prove I was disabled in 2017? If you have the evidence, you could prove it. But I'm going to tell you, practical matter, insight here, judges are really reluctant to go back that far because it's a long time to go back, 8, 9, 10 years and, try to figure out what somebody's condition was. Also, you were obviously younger 8 or 10 years ago, probably below 50. That makes it more difficult. And, a lot of records get lost or misplaced, and the doctor is retired or moved on, can't get anything new. It can be a real challenge, but it can be done. But work credits, it's a rolling, period of time that you're get work credits for. So yes, the work credits roll off as the longer you are not working, and you get to a certain point, and you won't have enough credits to easily, or if at all, prove Title II disability. I go for court March 30th. Very nervous. Any pointers? I've got a bunch of videos about this. And, again, I would tell you that the most important thing you can do in preparation for a hearing, I'll give you a number of tips. All right. Number one is that you need to have a very, very clear idea of your capacity. If it's physical, sitting, standing, walking, kneeling, crouching, stooping, lifting, all those type of things. You got to have answers for those things. And again, the answer would be what you might be like on a day, 4 on a 10, if it's a 10-point scale on a day 4, and give answers. You don't want to say it depends. You give them an answer. All right. So that's one pointer. Is you want to give a judge an answer. You're painting a picture of a average, slightly below average day. Number 2 is make sure your medical is updated. You don't want to go into a hearing with the last medical record a year and a half ago. Make sure that medical record is updated. If you have an attorney, that's what the attorney does. If you don't, that's what you got to do. So you want to make sure your medical record is updated. Number 3 is practice your testimony with your lawyer. Judges ask kind of the same questions over and over and over, and you want to be able to answer them. You're always going to be asked about your past work. How do you describe that? Make sure you understand, what it means to be a supervisor, when you're a working assistant supervisor that really had no hiring and firing authority. So you just be able to answer those kind of questions and to be able to discuss what you did very, very specifically. And of course, you want to be able to explain very concisely why you're not able to work. And you go through each injured section of your body, your back, your neck, your hands, your depression, and be able to go through and explain about each of those type of things. And of course, another big thing is to be honest. If the judge says, well, do you smoke cigarettes? And the record is clear that you still smoke 3 or 4 cigarettes a day, don't lie. Never want to lie because you're trying to give the judge something you think that he or she wants to hear. But that's kind of the gist of it. It's 45 minutes. It can be nerve-wracking. If you're doing a phone hearing, make sure the phone connection is good. Video hearing, make sure you got a clear signal. Make sure that your video camera, your phone, or your laptop is on a flat surface. You're not bouncing around. That gets judges upset. And just, prepare with your attorney. Prepare with your attorney to answer those questions and take his advice or her advice. You are very welcome. Madeline says, what is early acquiescence ruling? States they can make a decision about entitlement SSDI, the possibility as far as last year hearing decision. I have not read that. An acquiescence ruling is where a court comes up with a decision, Social Security looks at it and says, we're changing our policy. We're not going to challenge it. We're going to agree to it. And Madeline, I will look that up. I don't have, I've seen it a couple of times. I have not read it, so I don't want to speak to what it is. And obviously you're saying to me that it says they can make a decision about entitlement to SSDI. So it perhaps, well, I don't want to guess. I'm going to, let me see if there's anything I can find real quick. I think I know what you're getting at. Okay, what this seems to be talking about, and it really applies in according to Google, the great lawyer that is Google, it applies in the Sixth Circuit only. 6 circuits, Kentucky, Michigan, Ohio, and Tennessee, that if you had a previous decision, final decision at a hearing or recon or whatever, and then there is a new evaluation for a period of time that was not considered in that previous one, that prior finding can be used as evidence. So in other words, if you had a prior decision or hearing that covered a period of time from, let's say, February of 2022 to March of 2023, and now you have a new case and the time at issue is, April of 23 through May of 24, so it was not considered in the prior decision. You can cite the fact under the early acquiescence ruling that there was a previous finding, again, if you're in this particular circuit, that was made, and that is evidence that can be used. So, it seems to be, something that would give people something of a little bit of an advantage if they had a part of a decision that went their way before. Again, I don't want to be, again, I think it does seem to require us to consider prior findings. That's a good thing. But beyond that, I don't want to comment any more about it because I'm just sort of reading this on the fly. And again, it's been talked about a little bit on the NOSCR listserv. It doesn't apply everywhere, but I think it does just tell Social Security that they've got to be more internally consistent. They make a decision over here, and then they can't come back later, 2 years later, and say, oh, we're looking at the same issue and we're making a completely different decision. They want them to be more internally consistent. Because unless there's really evidence that there's been significant improvement, I think what this is probably getting at is that most people with chronic conditions are probably not going to get better. So unless there's evidence that they're one of the unusual folks who did get better as they got older, that the prior decision, prior determination should be binding. And this is very much in line with general legal principles. You may have heard of things called res judicata or collateral estoppel. These are two concepts in law in general where if an issue has been decided or a claim has been decided, a subsequent court can't go back and relitigate that. So if you are found, you've heard of double jeopardy in criminal cases, you are found not guilty, you can't be retried on the same issue, things like that. Or if a decision was made that you are entitled to this piece of property, another court can't come back later on and say, well, no, we think that's wrong, absent really unusual circumstances. So it is generally something to make courts internally consistent. I think that's what this is doing. But Madeline, I'm sure you will remind me to look this up, and I will see if I can give you something better. That may be actually a good blog post. Maybe we'll do that as a blog post at some point. I've been working on my blog a little more recently, and this might be a good one to do. Because there's another case that kind of something similar in a different circuit. And I did use that in a brief recently, so maybe we'll do that in a blog post. Okay. Lake City Bricks says, in a prior hearing, there was supposed to be a medical expert. He was not available at the start, didn't hear my testimony, but still tried to say my conditions were mild, and the judge challenged him. And so what we're getting at here is there was a medical expert called in Lake City's case. The medical expert did not hear testimony. And so basically the only thing the medical expert was going on was the medical record, which, is on paper, black and white on paper. And the judge, and then the medical experts offering an opinion about this is mild, this is not severe, this is something the person can still work. And, the attorney would say, well, wait a minute, you didn't hear what this person said, and isn't it true that pain can be subjective and blah, blah, blah. This case, the judge did it, which is a good thing. And that means the judge is advocating for the claimant. That's a very good thing. And, I've been in hearings where the judge, looked at the medical expert and it's like, that makes no sense. And, just dismissed him. So that can happen too. But medical experts, in my opinion, many times overstep their bounds by giving vocational testimony as opposed to limiting it just to the medical itself. But they do it sometimes. Okay. Andrew says, happy holidays. Happy holidays to you. Today is the second or third day of Hanukkah for us. And obviously this is a kind of a bittersweet Hanukkah after what happened in Australia. But it is people equate Hanukkah and Christmas. They're not the same thing. Hanukkah is a much more of a happy festival. It's not very religious, whereas Christmas is obviously much more religious. But it's a fun holiday, and little Jewish kids get a lot of presents because it's 8 days. Not usually a lot of big ones, but it's just a fun holiday, and it's a chance to get together with family and friends. So in fact, I was before this live stream. I had one of my closest friends' father passed away in a different state, and so we had a little get together at his house. Friends came over, and even though it was kind of a sad time, we did the Hanukkah lights because it's in our tradition you look at the good and the bad, and so this has happened to be a sad time, but it's also a happy time. In this case, the dad had kind of been going through a lot of health problems. He's not suffering anymore. So it was his time. It wasn't, it was sad, but not tragic. But again, you just got to look at life. And I will tell you, as you get older, you start to realize that every day is a blessing, and count your blessings, and be with people you want to be with, and do things you want to do, because you never know what tomorrow's going to bring. That was pretty philosophical, don't you think? But anyway, okay. Is reconsideration more winnable with a lawyer? Hard to really say. In all honesty, I think reconsideration is a waste of time. Might you get a little bit of an edge with a lawyer? Maybe. If you think you got a good argument and you can win on your own, go for it. I don't think a lawyer is going to make a huge difference. The biggest thing I do in a reconsideration is if I see a grid rule argument, or if I see something that I can make a kind of a unique argument about, I'll do that. But most of the time, it's just kind of, we disagree because you didn't read it properly, or if you look at the initial decision and there is not things that are missing, I may know more where to look, but I don't know. I think it's more. Let's put it this way: if you're going to get an attorney, I'd say get one at the beginning and get one before a hearing. Recon, yes, that's fine, but to me, it's more important if you're going to get one, either at the beginning to start you off right, or at the hearing where you definitely have to have somebody before a hearing. Recon, I could go either way on it. I don't think it's absolutely necessary, because it's probably going to be a moot point anyway, quite frankly. And if you're lucky and you win, then cool, you won, and you don't have to pay an attorney. So I don't have a problem with people doing their own recon. Kim Sol, I have a question. I'm 55, recently laid off. With severe glaucoma, myopic macular degeneration. Do you think it necessitates my vision loss? Very possible. I think the vision is actually more money, if I'm not mistaken, for vision. I would go to, I would look at listing 2, and I'm going to put that in the comments here. And I'm going to also share my screen. Let's see here, share screen. And this is the listing. If you've not seen what a listing is, it's called Social Security's Blue Book. And you will see that there are 3 of the listings, 2.02, 2.03, and 2.04, that talk about vision. So what I would tell you, Kim Sol, is print out this listing, at least 202, probably 203 and 204. Take it to your ophthalmologist and ask, do I meet or equal one of these listings? If you do, ask for a letter stating to that effect, and submit it. And I think you have a good chance of winning. You're very possibly close to listing level. I mean, you've got severe glaucoma, which obviously is going to interfere with your vision, myopic macular degeneration in both eyes. And, this one here talks about this listing, loss of central visual acuity. Remaining vision in the better eye is 2200 or less. That's the level of impairment you got to have. And these other ones are just different, different types of things. Contraction of visual field, which means you have no peripheral vision. So some of these may apply. You might be a listing level, and at vision, you'll get more money out of it, I think. So I would absolutely look at the listing, but go to listing 2, print out the first couple pages of it, take it to your doctor, and see if you can get a narrative report, a letter stating you meet the listing. And that would be a real good way to try to win early. Okay, so Lake City Bricks was asking, answering Andrew Weatherspoon. Andrew had the question. Let's see if I can find it, because look at these questions that kind of scroll away. I can't find Andrew's question, but okay. I do think that's overall good advice. If you have a lawyer, listen to your lawyer. Sometimes people don't do it. It's really frustrating when you spend an hour and a half on a pre-hearing call just talking about, you never say not very much and not very far. The first question, how much can you lift? Not very much. How far can you walk? Not too far. People get nervous. I actually tell people to write it down. In fact, I'm starting to do a little thing where I put a little spreadsheet together where I have the questions on them, and I send it to my clients, say, here are the questions you're going to get. Let's answer them. Let's go over it in our pre-hearing. I'm still kind of working on that, but just to try to get people something that they can refer to at their hearing. 5 years. Wow. 5 years. It's a long, long time. Well, I wish you the best. I know that's a long, long time. Glenn Johnson. My wife will be applying for SSDI soon. She has great documentation, and she wants to continue to work a couple of days a week or so, making $1,400 a month. I mean, in 2026, SGA is 1620 gross. So we're talking about gross, not net, number one. Number two, if your wife is paid bi-weekly, there are going to be 3 months in the year she's going to get paid 3 paychecks. So you got to be aware of that. Anytime somebody's working ongoing, $1,400 a month ongoing, and that's within a couple $100, almost $300 of SGA in 2026, but still not insubstantial. I mean, $1,400 a month is not going to, you're not going to be going to the Ritz-Carlton anytime soon, but it's still, fairly decent money for part-time work. There's going to be a little bit of a risk that they're going to look at it and say, well, how do we know she couldn't work another couple of days or a few more hours and get to $1,800 a month? So you get a little bit of that. I will tell you that, since the delays have gotten really long, judges seem a little more willing to accept the fact that people are working part-time and it's not as big of a deal that may represent their capacity. Now, if she's working, what is she doing in work? I think that's also a factor. I spoke to somebody the other day who, this is actually in the context of doing an appeal of an onset date. And my client said, well, I'm doing part-time work. I'm not making very much money, but what this person was doing was something very physical. And it wasn't, again, making a lot of money, but, 3 or 4 times a week doing this particular task was very physical. My concern was that, this task was really inconsistent with her underlying medical problems. And so you may get a judge looking at it saying, well, even though you do it 3 times a week, and I'll just use, it wasn't this, but let's just say it was lifting 75 pounds. The fact that you could do it 3 days a week, that says to me that, maybe your capacity is a little more restrictive than what some of these other opinions say. And again, in the context of our case, that allowed the judge to approve the case. So you got to be careful about that. So a couple of half days a week doesn't really bother me. The $1,400 doesn't really bother me. Just be aware that the free paycheck months and that there is going to be, it's going to elevate the risk a little bit, not a lot, but a little bit. And how risk tolerant are you? And, again, the wrong judge is going to see that as evidence that she has more compassion than she does. But again, the wrong judge is going to deny anyway. So wouldn't worry about it too much. Okay. 4 o'clock's been following me from the beginning. Wow. Well, I appreciate that. I know at the beginning it was kind of rough, but I appreciate that. Melissa says, how long does it take for a hearing to be set in Illinois? Letter states normally 75 days. I don't have Illinois specifically in mind, but I would tell you that generally when you request a hearing, most places it's 5 to 7 months because the hearings, they have plenty of judges. They just don't have enough personnel to get the cases worked up. And the 75 days, is kind of a minimum, but I'd say 5 months, 4, 5, 6 months, something like that. It's generally a little faster than recon and initial. Christina Harrington, my third attempt in the second hearing. Yeah, it's got to be frustrating to have to go through this over and over and over and to keep getting these same results. Any tips for an autistic adult applying for SSDI? Well, I would look at the listing for autism, although again, very, very hard to meet. And I'll tell you what that is. Let's see here. There is a listing, and I believe it would be listing 12.11. So go to look up listing 12.11. It's hard. I'm sorry, is it 12 point? I apologize, 12.10. And it basically talks about defects in communication, restricted, repetitive patterns of behavior. It's pretty severe autism. I mean, it's almost like nonverbal level autism. So hard to meet the listing. I think that, if the problem is nothing physical, you would really need to show that there's documentation of a real problem in interacting with others, understanding directions, acting within, operating within a schedule, operating, with, in a timely manner, not getting distracted, not having distractions by external stimuli. I know autistic people sometimes have noises will set them off, or smells or sounds, or scents, things like that. So I think that you just need to really figure out what are the reasons why you've not been able to hold jobs, and really trying to quantify that as much as possible. And again, if you've got help from a psychologist that can talk about that you don't pick up on cues, or that you were very distracted by sounds, or interaction with others, or things like that, that would be the way to go. It's very practical. How does your condition leave you unable to to be reliable at a job? And if you've been fired 7 or 8, 10 times, that's evidence as well. Okay, how would FERS or government annuity? Because if you look at the FERS regulation, it basically says that if somebody gets on Social Security, that it offsets FERS by the first year 100%, then I think 60% the next year. The problem is that it does not account for the attorney's fees part. So in other words, if you get, let's say that your FERS was $3,000 a month, and you get, Social Security, for that year, and it turns out to be, I don't know, $2,800 a month, whatever it may be, that you get a lump sum. The amount of money used to pay the attorney does not get reduced from what you'd have to pay the government back. So if you had a lump sum from Social Security or from FERS of, I don't know, $15,000, and lump sum from Social Security of $15,000, but you only got, $12,000 because of the attorney's fees, I'm just making up a number, they want the $15,000 back. So they don't give you credit for the attorney's fees like long-term disability companies do. That's one big problem with FERS. So you may end up owing money you never saw. That's a problem. Now, the second year is only 60%, so normally it kind of works out in the wash, but that can be a problem. That's the biggest issue with FERS, is the offset does not account for attorney's fees. And I'm not sure about the government annuity part. You have to just look at the language of the FERS. I know that has been an issue that I've dealt with before, is that you don't have, they don't account for the attorney's fees. But I don't know about the government annuity. I know nothing about that, unfortunately. What does this mean? Step 4. Okay. So what we're asked here is you'll see sometimes online in your My Social Security statement that somebody, a representative Social Security agent, has started a final review that you meet the non-medical requirements. I'm assuming SSDI case. The non-medical requirements would be that you have not gone back to work. In other words, when they do your Social Security disability analysis, they look at your earnings record. And so let's say that you say, I became disabled in February of 2000. We'll make it easy. I became disabled December 31 of 2023. Your earnings record shows $35,000 of earnings in 2024. Not consistent. So the person's going to want to say, explain this. Where is this coming from? Is it, you have to prove it's a severance package. It was accrued vacation. It was long-term disability, but if it was work, that would mean the onset date needs to be changed. So that's what they're looking for, is to see whether you have earnings that are not consistent with the onset date of your disability claim. And, I've had people, sometimes it doesn't happen often, but every once in a while somebody will say, well, my boss, treated me like a family. They paid me for a year, even though I wasn't going in. That's a hard sell. You got to really have evidence to that effect. You have to have somebody that can say, yeah, they paid Joe from going in and he wasn't there, but they paid him anyway. Not many employers will do that. Someone, I actually had a case a few years ago where my client worked for a family business, his own family. And so his family, I don't remember who it was, whether siblings or parents, they kept him on the payroll for years. He wasn't going in, wouldn't do anything because he had significant medical problems, but he's getting paid. And so one day Social Security sends a letter saying, we're looking at your earnings record and you've got $75,000, $80,000 a year for the past 5 years we've been paying you. You owe us money, pay us back. And we had to go to a hearing to basically prove that he was getting paid, but he wasn't doing anything. And, that's hard to prove. I mean, how many employers are going to let you, continue to get paid when you're not doing anything? And if it's your family, you kind of get close to that line. Are you defrauding the government? You're basically, trying to show that he's entitled to Social Security for earnings when he didn't do anything. So, is that going to get the family in trouble? There's consequences to these things. Okay. Michael Dean, FMLA, family medical leave for chronic back pain, anxiety, and depression. He exhausted his family medical leave and got fired. That does happen. 55 and the MRI comes back as unremarkable. Meds are gabapentin, Valium, and Seroquel. Again, this could be a chronic pain condition, a CRPS, a fibromyalgia. It would really be helpful if you had a medical diagnosis explaining or describing or characterizing this pain. What is it being caused by? It may not show up in an MRI or someplace else. Is there another test that it might show up on? Maybe an EMG, your nerve conduction study. Maybe there's a broken bone. There's a situation you have compression fractures. There's something called a PARS defect. You may see that on your medical record sometimes. That may not necessarily show up clearly in an MRI, but that could be causing problems. Maybe there's some other non-orthopedic issue that's causing severe pain. Maybe there's a psychological component to it. I don't know. I'm just saying, but you need to get some clear explanation as to why this is happening, because the MRI being negative is going to hurt you unless you have a reason to explain why the MRI should not be considered to be the gold standard test. Greetings from Los Angeles. Hello, Carmen. I hope you're doing well. Thank you. I was talking about rep today. Dave was busy, mentioned your videos, and knew exactly what I was talking about. Okay, great. So you have a rep named Dave who knew I am, and Dave knows who I am. Well, that's good. Yeah, I'm going to definitely, I think it's kind of fun to do the guest just because it's a chance for me to kind of bounce ideas off somebody else. And, I always like to get different perspective, and I learn things from that. So I know Stephanie Joy will come back on. She does her own live stream at noon or 1 o'clock or something on Wednesdays. So a lot of times she's kind of tired. She's already done it for an hour and a half, but I sometimes get her on. I know Lindsay Osterhout's been on a couple of times. So she gets up really early for, I think, some exercise class. So she don't like to stay till, 10:30. But again, I'll get her back on. I got a couple other people I'm talking to, some former Social Security people. I'm going to get Spencer Bishens back on. He was great. That was probably one of the more, active and really, I don't know what the right word for it, but just very engaging, energetic type of live streams, because he was very passionate about what he had to say. I want to get him back on. Okay, RB, I have an ALJ hearing in February of 26. A 50% approval rate. Okay, some full and partial. 52 autoimmune causing muscle wasting, some arthritis. Anybody over 50% is good. And I realize what you're saying is that maybe it's 43% fully and 7% partial, but that's still, 50% of the time he's giving an award. So that's a good thing. If you're 52, you might find him wanting to change your onset to your 50th birthday, something to consider. Autoimmune diseases are tough because they're hard to kind of pin down, but muscle wasting can be measured. So there's going to be some objective measurements there, some arthritis. I think, generally speaking, a 52-year-old with more or less subjective complaints, you're going to need to have a functional capacity form from a treating doctor. That's going to give you your best chances at winning. Because otherwise, if he could find you're able to do, light work, then you're going to be denied. So I would definitely see what you can do about getting a functional form from a treating doctor. Krebby Fantasy Art. Will they read my social media? Technically, they're not supposed to, but I tell you, put it on private. Don't tempt fate. They very well might. I mean, it's by no means, something that you're absolutely going to have, but I would not be surprised at all if judges do, because if it's in public, and I think I remember I told you all about this one case I had a number of years ago. My client was, I think she was like a 48, 49-year-old woman with bad back, and she was very overweight, but she, bad back and some foot issues. And her Facebook shows her climbing on a climbing wall. And I'm like, what the hell? What are you doing? Make this private, because, a judge sees that. And first of all, I'm like, why are you in a climbing wall? Well, that was 5 years ago. Well, it didn't say that. But, I just think it's one of these things where you're tempting fate. So just put it on private or close it. There's just no reason to have it out there. And, of course, there are sites that can go back and look at historical stuff. But I would say if you're going to file for disability, put your stuff on total private or delete it, be done with it. And by the way, on LinkedIn, a lot of people they're still working. They're, 2023, the present. Well, they stopped working in 2024. Change your LinkedIn to put that you stopped working. So if a judge looks at it, and a lot of judges are on LinkedIn, by the way. I'm not saying that they peruse it a lot, but they have LinkedIn profiles. Because I always like to look up, when I get a judge I don't know, I'll do a quick web search on him, or her, just to see, what type of work did they do before? Where do they go to school, to law school, to undergraduate? Sometimes they'll have something they're very passionate about on Facebook. They may have a profile that shows that they're president of this particular club, or that they're, the alumni, that they did this volunteer work. It's just always good to know that stuff. If a judge is a veteran, and I've got a client who was a military veteran, then a lot of times what's going to come up, there'll be a discussion about, rank and what they did. And I'll let my client know, this is a fellow veteran, and he may very well ask you about, these type of things. And so just, bone up on it so you can talk about it. And sometimes I've found, I think not always, but, there's a little bit of a connection there. Maybe that wouldn't be. So I'm like, okay, he was a veteran, you're a veteran. Talk about your time in the military. Make sure you bring it up quickly, and can't hurt. But I do think that you should assume that your social media is being read. Let's leave it at that. Okay, so Lake City said you went to quality review. And they, um, they did approve it within a couple of weeks, so it wasn't a big deal for you, which is good. Corleone Sports. You want to know how you win the case? I do. But I never want you to visit before putting us to stress. I want, other than quick prep, one, your chance of getting a cool judge. Okay, you know what? You want to know how I won? By never watching videos about putting us to stress. Like mine, not sure if you're being sarcastic or not, but you know what? If you find that watching videos and preparing gives you stress, don't do it. Maybe you didn't. I mean, I personally think I'd want to be as prepared as I could, given I've never been through this before, but to each his own. My opinion is, know the questions that are coming, practice answering them, and kind of know the process. When I started trying cases, when I was a beginning lawyer, 35 years ago, and when I started out, I literally would go to court, and this is before I did Social Security. I was just doing general litigation. I would go to court and watch. I would just go watch other experienced lawyers try cases, and just to get a sense of where to stand. And I remember my first civil trial, jury trial. It was in front of a really nice judge, but he's like, he's asked me to do something, and I can't remember what it was, and I didn't know the term, and maybe it was like stand in place or something. There's a term of art that they use. I had no idea what he was talking about. So I kind of stood up, and he's like, no. And he explained what it was, and he was very nice not to embarrass me. But, if you don't know where to stand, you can't focus on what you're thinking, is my opinion. So if you go into a hearing, you've never been through it before, knowing what questions are going to be asked, the order of things, how to answer questions, that to me would be calming as opposed to stress inducing, but to each his own, 65 with osteoporosis, polymyalgia, or rheumatica, which is kind of like a rheumatoid arthritis, spinal stenosis, a disability. Again, you don't win for a diagnosis, but these are all conditions that logically would have significant functional limitations. And at 65, you won't be expected to make any radical adjustment to a new job. So I would say more likely than not, probably a winning case. Now, if you're already getting Social Security retirement, the question is, does it make any sense to even bother with this? Because are you going to see any money out of it? That's a different question. But I think in terms of the merits, yeah, it sounds pretty good. Somebody else mentioned Ed Weir. That was what I was trying to think of, but I did come up with a name. What does someone do who has multiple long documented severe conditions they want to prove you? You just got to keep appealing. And this is the frustrating part about disability is, you get in front of judges who just don't want to approve you, and you get stuck with that judge. And, usually by the second appeal, they'll get to a different judge. But yeah, it's really frustrating. I know there's really nothing you can do other than, just keep appealing. And if you have to keep going back to the doctor to get more documentation, do that. Anonymous says schizoaffective disorder, bipolar, ADHD, OCD, obsessive compulsive disorder, PTSD, traumatic brain injury, diabetes type 2, high blood pressure, double sciatica, neuropathy. Again, all these conditions potentially have disabling impact. Whether they do in your case or not, it's going to depend what the medical record shows. You don't win because of a diagnosis or because of, these words. And I'm not minimizing what you've got. I'm just saying is that the diagnosis doesn't tell me what the functional limitations are. That's what you got to focus on. If I'm 60, Hal Clayton says, have to file for SSD, I end up waiting until I'm 62. Can I apply for early? Yes, absolutely, Hal. You can apply for disability, and then at 62, get early retirement, get some money coming in. Be aware, if you do that and you lose the disability case, you're forever stuck at the lower figure. If you win, you get bumped up. But if you're willing to take the risk that if you lose, you could be stuck at the 62 early retirement figure, then go for it. A lot of people do that. Michael, I'm 55 with chronic back pain. Intermittent FMLA. Okay. All right. I think we already answered that one there. Okay. TBI survivor here. Anybody out there with them? And TBI, traumatic brain injury, can be a real problem because it can lead to personality. I'll tell you what I've seen in some of my clients. Personality change. It can cause memory lapses. It can cause anger control issues. It can cause emotional instability. It can cause just a whole host of things. I mean, the brain is kind of squishy, and you get it injured, and you never know what part of it's going to get impacted. But you need a neurologist or maybe a neuropsychiatrist is really what you need, or was it neuropsychology? A neuropsych, I guess, a psychiatrist, and or psychologist. I guess it's, I don't know. I think it's a neuropsychological, so it could be a psychologist, a neuropsych evaluation. So I think if you've got a TBI, it wouldn't be a bad idea to get a neuropsych evaluation to get a sense of the functional deficits that have accrued since your TBI. It would also help to have third-party statements, like from a former coworker or from someone who knows you, talking about the changes that you've got and specifically the changes that would make you less reliable or likable at work. Maybe you become oppositional. Maybe you have fatigue issues. Maybe you have memory issues, sensitivity to light, any number of things. But you want to identify all those things that could potentially have work preclusive issues. Hakasad, what is the DD prep for since not sent to the claimant by default? Who is a DD? Oh, this is basically Social Security. What Hakasad is asking, I hope I'm pronouncing that right, is, when the state agency does their analysis, they do this written analysis, it doesn't get sent to the claimant, but it's part of the file. It's just documenting things for quality control for a judge down the road. They're required to document their reasons for things. But you make a very good point, is if it's not sent to you, they sent you a summary of what they said. We felt you could go back to past work, but the disability determination explanation may be 15 pages. You raise a very good point. Why isn't that sent to the claimant so they know exactly why they were turned down? Doesn't make a lot of sense, but they don't give it to you. Now, I can get it later on, and I'll send it to my client, but yeah, that's a very good point. I don't know why they don't send it to you, but it's because they have to document it, but they don't have to tell you about it. Seems crazy. What do I do if I haven't worked? Well, if you can't have the credits, you're going to have to either go for SSI or go for an onset date prior to your date last insured. That's the problem. I talk to people periodically that don't have the credits, will never have the credits, and I can't really help you. So it's not what you could do. When my personal injury, which I should, I will try to get a disability. Otherwise, you are blanked. Yeah, I hear you. And you don't, you want to make sure you allege disability and that you have enough, you do it before your date last insured. So if you get turned down, you could try it again. But yeah, it's a problem. Definitely a problem if you can't work and you get turned down. Okay. Crimes on fire. If I had pretty much my full medical record missing, so what they're saying is at initial and recon, the medical record was incomplete. Now I've got the whole medical record. I turned it into Social Security, waiting for an ALJ hearing. Is it possible we not need to attend? It is possible. The judge could look at that and say, I'm going to issue an on-the-record decision. That has happened to me a number of times. I think it would help, though, to do a written explanation as to why you're deserving of that on-the-record decision, because I think you want to give the judge as much information as possible to make that decision for yourself. I call it a pre-hearing brief, but same concept. And literally, I'm just going to tell you, this is not the ideal way to do it, but stick the medical record into a paid version of, an AI engine like ChatGPT or Perplexity or, Notebook LM, whatever you got, and let it help you put together something. Draft me a brief using the 5-step sequential evaluation process, and modify it because it won't always be right, but that may be a good way to get started and to do it on your own with a little more professionalism. So, how long does it take to get an SSDI now on the stage? I mean, the whole process in general, the timeline I give people is assume a year, 9 months to a year for initial, maybe 7 to 10 months for recon, maybe another 6, 7, 8 months for a hearing. So you're generally looking at, I'm trying cases now for people that applied, 2 years ago. If they're 100% VA, maybe they applied a year ago because that moves in the front of but I would front of the line. But I'd say for non 100% VA people, it's going to be 2 to 2.5 years, start to finish. Again, a good question. Renegades Garage. What is the point of going back to the doctor if they keep telling you there's nothing they can do for you? Why keep coming back? Yeah, that's a good point. But I just, if you don't have a medical record, it's going to be hard to win Social Security. Just to check in, is there anything new that's come out? Any new drugs, any new procedures, anything else that can be done for me? There's no reason. It's just paper trail. You got to do it. You got to do it. How cases to you? I'm not sure if you're asking me how many cases. I probably turn over about 300 to 350 a year. Larry Jones, I'm 63 and SSDI. I kind of switched to regular. If you're on SSDI, I would just wait, let them do it automatically. I don't see there's a reason to switch it. Why would you want to switch? You're getting the same money. Verify that you're getting the same money, but I think you're just getting the same money. And in fact, I think if you switch, 63, you wouldn't be eligible for Medicare, but with your own disability, you would. So I don't know why you'd want to switch. Christina says, press that like button. Yep, do it. All right, we were getting about 15 more minutes. Okay, do I need some medical documentation supporting my disability claim or the functional capacity assessment completed by PCP? I don't think it's a problem to do that. I know some adjudicators want to get their own records, but you know what? Be your own advocate. If you got all that stuff, submit it. I don't see why not. I don't think there's any harm in doing it. CE docs do the same thing. You said that the bottom of the barrel, they filed many objections to this. It means mental interrogatories. Yeah, the CE doctors, and realize we had John Foster on the live stream a few months ago, and he's a CE doctor, and he gave a very impressive presentation about what he does. I would agree with you. A lot of these doctors are just kind of, doc in a box type of doctors or industrial clinic doctors, not very impressive. The psychologists, though, tend to be a little more mainstream. They're practicing doctors who do this to make extra money, but they're used to finding mental health problems with people. So I don't have much of a problem with those. But the industrial clinic doctors who just see claims for insurance companies, they're going to find nothing wrong with you. And half the time, their reports don't even say anything. They don't talk about any functional limitations at all. So they're kind of useless, in my opinion. Get your DD regardless of denied or approved. Receive my denial on this zero reason after request of DDA. Yeah. Okay. So what Hakasad is saying is there is an explanation of the administrative decision. So you have the administrative decision, it's the cover, the form letter, 3 pages. We denied you, we approved you, and we looked at these medical records. It's very form. The explanation is 9 or 10 pages. If you can get that, that can be helpful. Gives a nice summary of the medical sometimes as well. All right, Renegades Garage, this is the person with the visual problems. Right eye is 2200. Well, they're saying 2200 in the better eye. So it would have to be the left eye is 2200 or worse. But if your left eye probably is 2100, then you wouldn't technically meet the listing. You could maybe equal the listing because you're really close, but to meet it, that you have 2200 in the better eye. Maureen, good evening. Hello, Maureen. Dave, okay. Dave Chermall. Okay, Dave is a well-known attorney, very well respected, non-therapist. Josh Green, working remotely for the firm from Kentucky. Don't know Josh. Again, Dave knows what he's doing. So, I would just tell you that, given who you've got in your corner, you're in pretty good shape, I believe. I mean, again, I don't want to speak to people I don't know, but I do. Dave's got a good reputation, and I've met him a couple of times, and I think that you're in good hands there. I think at least either you or somebody asked that. I just would say with social media accounts, put them on private. Just don't leave them. I mean, if you got to leave them up, don't put anything, don't post anything new. Certainly don't post a picture of you doing anything that's inconsistent with your claimed disability. I just say put them on private or close them if you can. It can hurt you. It's never going to help you. Put it that way. Judges have backdoors to see social media. Okay, yeah, I would agree with that. They're not always going to be an agency issued equipment. They may have their own computer, or maybe if they're really curious, their spouse or their friend could log them on. I mean, you just never know. And again, I don't want to make it seem like judges are these sneaky people looking for reasons to deny. Most of them are not. But, they also want to do the right thing, and they don't want to be played for a fool. And so if they see a record that seems a little bit questionable to them, they might go look at the social media profile just to see, is their hunch right? So don't give them that ammunition. Christina has not worked in 20 years raising her kids. Well, you won't get SSDI unless you are doing it under a deceased spouse's earnings record or divorced spouse's earnings record. SSI would be if your household income is below a very low limit. Otherwise, you might be just out of luck. It just depends on the numbers. Indigenous Iron. Okay. If someone receives SSI and disability, it's a 2,000 asset limit to them. Well, I mean, if you typically SSDI offsets SSI, but yeah, the $2,000 limit does apply, whether you're receiving it or you're considering it. Yeah, absolutely. In fact, if you exceed it for that particular month, they'll make you pay them back or they won't pay you for it. In other words, let's say that you get a lump sum. I think with SSI situation, if you get your lump sum from SSI, they give you like 6 months or a year to spend it down. But after that, you got to, having that money is a problem. And I've known people that have created these trusts. There's other ways to deal with it. But again, it's beyond my knowledge base, but I know there's some ways you can do it with an estate attorney. I've been an SSDI, says user XY, for about 5 years, thinking about working for $300 to $400 a month. I don't think that's going to move the meter. No, that's very short. That's not a whole lot of money. I don't think that's going to be a problem. Renegade's Garage guy. I applied, denied, appealed, denied. Talked to the lawyer, wouldn't take the case. Would be like him. The judge, she was wrong. Now that's a bogus reason to not appeal a case. Of course, you're telling the judge they were wrong. That's why you're appealing it. Judges have to realize it's not personal, and most of them do. I don't know any judges who, if you appeal them, are going to take it out personally. Look, there's a judge here locally, one of the hearing offices here, that is, I find him to be very disagreeable. He turns down a lot of cases. I almost always appeal him. I almost always win the appeal. He eventually grants. It's a little game, and I don't know if it's with me. I just think he's just that way with everybody. I don't think that he sees it as I appealed him. He's taking it personally. I appealed him because I'm representing my client, and I came up with a reason. If he made a mistake, he doesn't agree. And I've had him. There was one case I had where he issued a 2.5-page footnote to the decision, basically saying he vehemently disagreed with the appeals council's decision or district court's decision, but he had to change his ruling because of what they said, but he didn't want to do it. So he had a connection, but he was mad at them, not so much about me. I don't think that judges get mad at the claimant or the lawyer for appealing them because they're trying to get benefits. They may get mad at the next level up or whatever, but not usually at the claimant or their attorney. Yeah, Renegade's Garage, 5 out of 10. If you don't have enough credits, you would not qualify. That is very true. Dias Missertor. If your back work is labor and you have bad shoulders, knees, back, again, that sort of sounds like grid rule territory. And yet, look, if you get denied an initial recon, appeal it. I mean, every case I try has been turned down twice. They miss a lot of stuff. And the other thing, and no one's mentioned this before, but I'll tell you, when you look at these explanations, it could be a urologist making an opinion about an orthopedic case, a gynecologist making an opinion about, I think, a traumatic brain injury. A lot of times the doctors they're just medical doctors, which, look, it's hard to get through medical school, but imagine you went to medical school 15 years ago and now you've been practicing as a, gynecologist, and now you're trying to make an evaluation of a traumatic brain injury. Are you really the right person to do that? Probably not. And sometimes, of course, they're not looking at all the records. They don't sometimes have the benefit of the claimant's testimony or statements. So it's not written in stone, So yeah, I would definitely say Diaz, appeal. Renegade's Garage, bulge, disc tumor in the spine, permanent nerve damage, saying I had bad vision when you were talking about it. Okay, so you got a lot of stuff going on. I mean, I think you've got a pretty strong argument if you have the insurance credits. That's the big issue. Okay, I got time for a couple more. DWS is an above-the-knee amputee with no work in recent history and an SSI application process. Yeah, I would definitely let them know. Your question is, should you let them know you qualify under the grid? Absolutely. You probably qualify under the listing. Look at listing 1. I think if you've got a above the knee amputation, you may meet the listing, because they're going to assume there's really not a lot of jobs you could do, but you also have the grid rule. But absolutely mention it to them. There's no reason to hide it. It doesn't benefit you. Let them know. Okay, there's more about the credits there. Okay. All right. Well, we're right at about almost at 2 hours. So I'm going to go ahead. I don't have any more questions. I don't see. Let me just see if there's any more that have come in. But I think we're in pretty good shape here. Okay. All right. So I think I mentioned this before. This is the last live stream of the year. Next week is Christmas Eve, I believe. Is that right? Let's see here. Weeks go by. Yes, it is Christmas Eve next week. So I think most people are not going to be on. I may or may not be even in town, although I've done it from out of town, but we're not going to do it on Christmas Eve. And then the following week is New Year's Eve. Not going to do it New Year's Eve. So I will be back on Wednesday, the 7th of January. So you're all going to have to go 2 weeks without seeing me. And the good news is I've got a lot of recordings, so you can get your fill of looking at my face for the next 2 weeks, looking at my recording. Big facetious there. But yeah, I'm just going to the next 2 weeks, because of Christmas Eve and New Year's Eve, just felt like no one's going to really want to be on, or they're going to be focusing on other things. So I get that. That's fine. So I wish everybody a very, very meaningful and safe holiday, whatever holiday you celebrate. If it's Christmas, Merry Christmas, a meaningful Merry Christmas, and for everybody a happy and safe New Year. If there's other holidays you're celebrating, I wish you the best for those. I mean, I think this has been a crazy year in a lot of respects. Unfortunately, a lot of violence, a lot of political violence, a lot of division. We're not a political show here, but I do think, I will just say this, 2 comments. One is that I think in a lot of ways social media is driving a lot of this division. It's causing people to turn against each other. Not a good thing. I think a lot of this, social media nonsense is maybe driven by outside forces, countries that are putting money behind it to, make us turn on each other, which is not a good thing. And I think we're stronger, together. I mean, the differences between the left and the right, most people is not that great. Maybe there's this one thinks about, they have this policy, they believe in this social policy. But for the most part, if you talk to somebody on the other side of wherever you are, there's a lot you may have in common values. So, I think that my wish for the new year would be that, we focus more on the things that unite us to make us this great country than the things that divide us. That's point one. And point two is, Social Security is a difficult system. It's a very difficult system. And, the more you can educate yourself, in my opinion, the better off you're going to be. So ask questions, use all the resources out there. Use ChatGPT, use Perplexity, look at websites, come to my live stream, go to Walter's live stream, go to Stephanie's live stream, learn what you can. I mean, you have to be an educated, consumer. I remember there was a retail store in Atlanta called Sims. I think we're way out of business now, but they're saying was an educated customer is our best client, or something to that effect. And I think that's true with this. The more you know, the better you're going to do, because you'll know what to say. The more you can prepare yourself, the better you're going to be. So use these resources. There's more information out there free than there ever has been before. I mean, when I started doing this, there was no internet, there was no websites, there were no live streams, there was no books. You couldn't go to see hearings. This is an amazing time. So I would tell you take advantage of it. Take advantage of it and really learn what you can. So anyway, I wish everybody health and peace and goodwill for the new year. And let's make 2026 a good year. If you're applying for disability, let's try to get it. If you're just trying to make sure you don't get reviewed and terminated, let's try to make that happen. And if you're just listening because you want to educate yourself, good for you. And I'll keep turning in. I'll try to make this as enjoyable as I possibly can, and to give you as much knowledge as I possibly can. So I wish you all the best. I will see you on January 7th in the year 2026. Take care, everybody. Bye-bye.